So look at the contracts in detail. If they're already underway, that may be a bit of a problem, but in many instances, you can go back to your consulting partner and say, this really doesn't look fair to us. We'd like to renegotiate this aspect of the contract. And they're usually going to be open to do that because they want to have goodwill between you and them. But if you're seeing something that looks sketchy in the contract, make sure you have a lawyer look over it. Make sure you really kind of ask some of the core questions. And make sure you're signing the contracts that you feel good about. And I know with a bunch of legal mumbo jumbo in these things, and different kinds of resolutionary processes and procedures, things like that, they're tough to read. But let me tell you, everything kind of falls back to the contract. And if a relationship goes bad and goes south, in other words, they're doing stuff that you don't believe they should be doing, such as picking the wrong architecture and not returning value to the business. And it does get down into arbitration, or it does get down into litigation, then you're protected if the contracts are written correctly. So make sure you engage lawyers and make sure the contracts are aligned to what your needs are and to the needs of the business. So next, be extra wary of so-called proprietary accelerators, hidden IP. These are often called, gimmicks, and they will lock you in to a particular, state or a particular path or a particular tool. Many of these consulting organizations, in order to set themselves apart, have created proprietary approaches, frameworks, things like that they view as unique to them. And they're going to consider that IP, and they're not going to turn that over to you. And so if you're using their tools and their processes, and they can't prove to you that you're able to take that IP back into your organization and use it even independent of the consulting firms being released, then that's going to be an issue. So watch for the gimmicks.